Expatiate. Sorry for keeping everybody waiting.
It's all right, ma'am. We hardly welcome you. It's a pleasure having you around.
Thank you. Thank you.
A very
Okay.
warm evening to
Yeah.
ma'am. Shall I start the session first
Yes.
with your introduction and then we will lead on?
Yeah.
A very warm evening to all the attendees presented over here. We, the team Legal Expatiate, feel privileged to welcome you all to the last day of our 7-day online certificate course on domestic violence and 498 matters. We are privileged to have Honorable Advocate Roma Bhagat ma'am for today's session. Now, I take this opportunity to briefly introduce our honorable speaker to you all. Honorable Advocate Roma Bhagat ma'am has worked for over 38 years as a legal professional in various areas of civil and criminal law, including laws related to persons with disability, intellectual property, services, custom and excise, FERA and corporate society and arbitration. Madam Bhagat has a large chamber of practice in documentation, contracts, opinions, and legal advisory, and has handled very prestigious and highly reputable client work in disability sector encompasses a legal aid training and capacity building of all the stakeholders, advocacy, and policy work. With that, respected ma'am has been the point person for the NHRC in organizing judicial colloquium and disability for the list for 52 judges from high courts of all over the country. Madam Bhagat has further been a recognized trainer for the National Trust for Persons with Autism, Mental Retardation, and Multiple Disability and the Rehabilitation Council of India, has been part of working groups for Planning Commission of India in 11th and 12th Plan, and has been a part of training programs in the Vulnerable Witness Program of Delhi High Court and Delhi Judicial Academy, aimed at training district court judges, public prosecutors, and the police on handling disabled litigant and witnesses. She has been the legal trustee for the Special Olympic Sports for the mentally challenged and drafted child protection and sexual harassment policies for various disability organization and other mainstream or groups organization and feel or argued PILS on behalf or the benefit for the person with disability. As part of her chamber practice, Ms. Bhagat has also handled litigation, advisory, and contract for numerous public sector undertakings such as Rashtriya Chemical Fertilizer Limited, GAIL, Coal India, Navy Litigant Corporation, Indraprasth Gas, IGL, etc. Honorable Ma'am has also represented the government of NCT Delhi from 2015 to 18 before High Court of Delhi as a council. She presently represents Yamuna Express Industrial Development Authority before High Court of Delhi, Allahabad High Court, National Green Tribunal, and NCTRC as a standing counsel. She has also been a part of several arbitration proceedings, both as an arbitrator and as a counsel, especially dealing with the international work contracts. Ms. Bhagat has also the co-chair of the Legal Reforms Committee and members of the Land Reforms Committee of Associate Chamber of Commerce and Industry, India. During the course of her work, Honorable Ma'am on many occasions has been a speaker on issues relating to land reform and housing at the conference. Beside working on the policy issue at various levels, including the planning of commission, she has appeared before the parliamentary committee as an expert witness on social housing and has been part of expert group at the Asia Pacific Ministerial Conference 2005 on housing and human shelter. Apart from that, respected ma'am has also worked as a patent agent with international intellectual property firm, referee, where she has handled trademark filing and opposition arguments before the Registrar of Trademarks, Patent Office, Copyrights Board for the firm's domestic and international clients, such as Cartier, White, Westinghouse International, etc. Madam Bhagat has also extensively worked in real estate sector all over the country, particularly related to revenue law. An interesting facet of this area work has been drafting of contract as well as pleading of NRIs within the legal framework and acceptability of local laws of the country of immigration. Ma'am has personally and in conjunction with local lawyers handled innumerable litigation in civil, criminal, service, intellectual property, sports and disability law in Delhi and other part of the India. She has also written articles and column in various magazines and journals and has co-edited issues in Seminar magazine on multiple topics and has been voluntarily imparting legal education to various stakeholders. As a lawyer, Madam Bhagat has appeared in Honorable Supreme Court of India, High Court of all over India, and NCDRC and State Commission Consumer Forum, Registrar of Trademarks, Patent Office, Copyright Board, Central Administrative Tribunal, Registrar of Cooperative Society, and the Delhi Cooperative Tribunal, Enforcement Directorate, and the Central Exercise and the Gold Control Appellate Tribunal, Director General of Foreign Trade, and etc. As there is no end to her achievement, we are fortunate enough to have such an eminent and renowned personality on our platform today. We are blessed that ma'am has taken some time from her out from her busy schedule and agreed to spend an evening with us today. We heartily welcome you, ma'am. It's a pleasure having you around. Before we proceed to the session, I request all the participants to not create any hindrance in the ongoing session. I request our honorable speaker to kindly take over the charge and enlighten us all. Over to you, ma'am.
Thank you so much. I'm sorry I didn't get your name. What is your name?
Ma'am, it's Advocate Akanksha.
Thank you so much, Akanksha. That was quite, I was just a little amazed because I honestly never sort of viewed myself as being kind of eminent, but thank you. That was quite an introduction. So now to get to the DV Act. So how many of you are, and please, whenever you want to, just put on your mics and answer, or you can put it in the chat and somebody can just answer, for everybody collectively. So how many of you all are familiar with DV? How many of you all are familiar with the DV Act? Most of you guys. Yeah? Okay. So essentially, when we're talking of domestic violence, why was there a need for domestic violence? That's very important to understand. Because before the Domestic Violence Act came in, there were a few things that were not available to women. The first was that a live-in relationship without marriage did not have any legal standing whatsoever. It's the Domestic Violence Act with its idea of a shared household that actually gave a kind of sanctity, so to speak, to a live-in relationship where a woman could claim some benefits under the Domestic Violence Act. So that is the first thing. The second thing is that Domestic Violence Act for the first time introduced 4 different kinds of abuse, in which financial abuse and mental abuse. So it looked at the uh, the epistemology of a woman who comes from a background of abuse, right? And this is really important to remember, because what happens is that, during our practice, there's a lot of matrimonial cases that come to our chambers. And what I've realized is that when when I read the pleadings, um, I realize that people just focus on the financial aspect and they focus on the physical aspect, but they don't really focus on the psychosocial aspect of it. What happens to a woman if she's a victim of abuse? What remedies can she take? What remedies can't she take? So right now, currently, as we speak, we are dealing with one matter where the woman was thrown out of the matrimonial home some 14 years ago. Okay. Then and when she was thrown out, she was kind of uh, thrown out a little politely. She was told that you leave and go and stay in this flat which is being provided for you. So she was staying with the in-laws. She was told that the space that is being occupied by her and her two daughters is required for another member of the family, and she was told to leave. And she was told that, oh, it's, you'll be provided for in this flat which is also owned by the family, husband, whatever you like to call it, right? So sorry, just give me a moment, guys. Sorry. So um and when she arrived at the flat with her two daughters, she realized that it was actually an unfinished flat. No way that anybody could have lived there. So she literally was on the streets, went to a friend's house, spent the night with her wondering what to do. Then the friend said, no, you stay here, helped her to get the flat in order, up and running. Then she shifted there with her daughters, and sometime later was told that she's going to be shifted to another flat, with which she also complied. Okay, that also demand she complied with. Now, the daughters grew up, and in 2018, which was 9 years after she left the matrimonial home of the in-laws, which that she had with the in-laws, the first matrimonial home, she um, uh, the husband was being a little violent, and her daughters, who were then grown up, the younger daughter called the police. Now, the husband was so upset over this situation that he walked out of the house and he never came back. And he stopped supporting them monetarily. Despite that, um, so the husband, over this period of 9 years, had sort of been using the house as a hotel. He would come for a while, stay for 2, 3 days, then leave. His excuse was that he was working abroad, and he used to send money to her with precise instructions on how to do things, where to put the money, what to do with it, etc., etc., which she would follow faithfully. So she was like his PA. She was behaving like his PA. And then he walked out in 2018. She didn't have a job. She had two children, both of whom were studying. And he told her very categorically that I'm not going to be paying you anything from now onwards. Now, at that stage, you would think that, okay, this woman who's not working, hasn't worked for the longest time, and has two daughters to support, would be a little conscious of how things are going to pan out. Despite this, she's so used to obeying the husband that he sent her emails to say, you have this money, which was running in lakhs, like close to 50 lakhs. He said, I need you to send this to this one, this to this one, this you send here, this you pay out here, so on and so forth. And he completely cleaned her out of all the 50 lakhs, right? Now, this is a typical case of psychological abuse. So when we filed the domestic violence not only against the husband, but also against the mother-in-law. And the judge, the father-in-law had passed away by then. The judge she said, you left the house 9 years ago. So I said, yes, but we're still claiming that it's a continuing violence because this woman was not in a position to file anything because of the mental state in which she was. So you cannot look at the gap between her living with her mother-in-law and the filing of the complaint in terms of the fact that the mother-in-law hasn't been actively involved in her life. You have to look at it in terms of whether or not she was competent to actually file this complaint. Because if you see it, it's reached to this point of the complaint only because the daughters are involved, and the daughters who are now grown up and are kind of taking charge a little bit, and are able to persuade their mother and to support her, to give her strength. Um that's why, and also the desperation of not having any money. I said that's why she's been able to complain today. That's why we are standing in court. So you have to look at her psychological framework, her mental makeup, and then decide. Because, for example, and I sort of want to say this to all of you. For example, if this woman had been, let's say, declared to be mentally not sound, then all the time that she was declared to be mentally not capable would have been automatically excused in limitation. And we are saying that in a situation like this, where she's demonstrably, even after the husband has left her, and one of her children had to give up their studies, you know, because there just wasn't enough money. Despite that, she paid out almost 50 lakhs, which she shouldn't have. She should have just kept it. If she'd come to a lawyer earlier, if she'd spoken to somebody, the lawyers I would have advised that you just hold on to the money and tell him, I need it to support myself and my children. You're not paying anything. When you start paying, I'll also start sending the money out, you know. So this aspect, see, the difficulty was she came to us quite late. And this aspect had actually never been taken into consideration. We had to withdraw her DD and refile a fresh one with fresh grounds, because the earlier lawyer whom she had before she came to us had not bothered to take this on board, had not bothered to read up about it, had not bothered to examine it from this point of view, and therefore had prepared a case purely on financial grounds, right? So at this point, I want to stop. And are there any questions that anybody wants to ask? Because we'll do this question answer thing as we go along. It will be a lot easier rather than you trying to remember and me trying to give you answers, which are all mixed up together. Any questions? Anybody wants to know something or about this aspect? Will somebody just verbalize it, please?
Good evening, ma'am. A quick question. Is
Yes.
the law of limitation somewhere applicable? Because a 9-year-old case, this case looks to be a genuine, but if a fraudulent case has to be filed by, which is very common in DV case. Someone says, I have gone through a mental torture 9-10 years back, and these are the reasons.
Yes.
It
So
can be done.
The DV Act stipulates 2 years. We all know this, right? So, and that's where the judge was going also. But remember one thing: when you allege fraud, you need to prove fraud. But when you allege that you were not competent, you have to prove it also. No.
So in this case, ma'am,
Can't be. So it can't
9-year-old.
be.
Yeah.
Yeah, it
Sorry.
can't be a situation where it's just a simple say so. I say I was mentally incompetent. What do your actions demonstrate? Were you genuinely mentally incompetent, or were you not?
Ma'am, in this case, could the court would have asked for an expert witness like a counselor or a psychiatrist, because all these are very subjective conjunctures about the mental situation of the wife.
Yes, to some extent they are subjective, of course. But the
But is
question,
it like mandatory for the court to ask for the expert witness to opine or to help
no,
the
they
court?
did not actually call for any expert witness. But let me put it to you like this. So you're all familiar with 498A, right? And 498A categorically states that if the 498A is filed within 7 years of marriage, the presumption is that there was a dowry demand, and therefore it will be on the respondents or the accused to prove that they did not take any or ask for any dowry, and they did not harass the girl for that purpose, right? However, if you look at the judgments, what has happened is the courts, how have they interpreted it? The courts have interpreted it to say that this 7 years could be continuing beyond the 7-year period, where the woman has been reduced to a stage where she's just not able to complain, and that's something that we have to take on board today across the world. um, More and more people are looking at what is called typically the battered wife syndrome, where there have been cases where heinous crimes have been committed by women. But the fact of the matter is, the question then before the court is the woman more sinned against than sinning? Did it just reach a point where she couldn't take it anymore, this daily abuse, and she sort of did something horrific? Like, for example, I don't know if you're all familiar with the Bobbitt case, where Lorena Bobbitt castrated her husband, you know, or in fact, there was a movie that was made on this other case in England, where this woman just woke up one morning and set fire to her husband. She killed him, and then she actually the trial court sentenced her. But then her case was taken up by a women's organization who helped her to realize. She studied inside the prison, and then she filed an appeal. And in appeal, it was recognized that the kind of horrific abuse that she had suffered had led to a point where she was, at the time when she committed the crime, she was not in her directing mind. So she was almost catatonic. All she could think of was, I need to get rid of this abuse. Full stop. Nothing more. Okay. So I have to put an end to this. I just have to stop it. Nothing more. And so that person who's not does not have at that moment legal capacity, that under law they can't be held accountable for their actions, right? So again, when you assess, it's a case to case thing. All I'm saying to you is that if such is the case, and if you have some evidence to show that the woman was in a situation, one, of abuse, and two, where she was not able to use her mental faculties completely, or she was so used to obeying that she would do things which were actually harmful to her, then you need to take this plea. This is important, right? Also, yeah, anyway, so let's finish with this, then we come on to the next thing. So does anybody have any further queries on this one? Yeah, we're all clear? Okay. Also, when you file a DV, okay, now you have 4 different kinds of abuse. So normally what happens is that DV petitions tend to be kind of a copy paste of a 498A. तो सब कुछ डाल देते हैं उसपे, मतलब from beginning to end. There was harassment all across the board. This happened, that happened, all kinds of 150 things happened, right? Physical, mental, sexual, the father-in-law, the brother-in-law, anybody who happens to be staying in the house, all kinds of things. To my mind, this is not good practice. Please look at your client, look at what she needs. Sometimes women just need the financial, resources. And if that's the case, then you just need to file that she's being starved financially, like she's being starved materially. She's not being given maintenance. She's capable of maintaining herself. Maybe she's not educated, or maybe she left her job because her children were small and it's been 10-15 years. It will be difficult for her to get a job now. Maybe she's working in a sector where she can't get a job which will earn her the kind of money to ensure the kind of lifestyle her children were used to, and that's what she wants to give them. So there are all these reasons, right? Stick with what you need relief for. Sometimes it's not necessary to say that she was beaten 3 times a day, the father-in-law made sexual overtures. It's all irrelevant. And that's the reason a lot of DVs actually, if the respondent is determined that they're going to push it to the very end, they fall flat. Usually they get settled because the parties get tired. So yes, sometimes it pays off, because then what happens is that you're able to get quick relief in the beginning, but eventually your case will not hold up, right? So don't make a case that won't hold up, right? Make a case that will hold up, and make it a little carefully, keeping your client's needs in mind. Okay? Yeah, any questions up to this point? No. All right. So we move on to the next thing. Now, I was told as a part of, what exactly you all wanted me to talk about, you all wanted me to talk about the appellate procedure. So is anybody aware where an appeal will go from a DV? Supposing an interim maintenance is decided against you, or the DV is decided against you, where will the appeal go? Is anybody aware?
City court.
Magistrate.
So from magistrate to city court, sessions.
That's right. So it goes from the magistrate to the sessions court. Okay. So be very clear about this. Your appellate procedure leads you from the magistrate's court to the sessions court. Okay. You go to sessions in an appeal. Now, I was asked to elaborate on how exactly an appeal can be filed, what would the pleadings look like. It's very simple. Okay. Basically, in any appeal, it doesn't matter whether it's DV or it's any other matter. Okay. What you need to do is you need to look at the order that has been passed, the judgment. Look at the judgment and look at the pleadings and the examination and cross-examination of witnesses. All right. And cull out every single point that either has been missed, which is in your favor, or has been wrongly interpreted, or has been not properly dealt with, ignored. Yeah. Once you have that, that's going to be the body of what you're going to say. In every appeal, how your pleadings should go is that in your first paragraph, you explain what are the reliefs you're seeking, which is basically setting aside of this particular judgment and decree dated so-and-so, or the interim order dated so-and-so, maintenance order, right? And then you go on to stating that you want to give a brief summary of the facts. So put down a factual matrix. Okay. In the factual matrix, what we do in my chamber is we number it as a particular paragraph, for example, para 2. And within that, we make sub-paragraphs. Because when we plead, we ensure that we don't put too much information in one paragraph. We keep each paragraph very short and simple. Usually in one sentence, we finish it off. And we ensure that every new point comes in a new paragraph. Reason being that anybody who's in a hurry, and believe me, every judge is in a hurry, they have 100 cases to deal with, or whatever it is they have, they don't have the time. So the tendency of any person who's speed reading a document is that once they've read the first sentence of a paragraph, they think they've got it. And then they skip to the next paragraph without realizing that that paragraph may have three sets of information, of which they've only got one. So if you put your three sets of information in the, you know, the paragraph and the two paragraphs following, then usually the judge casts a glance over it and, you know, realizes that, okay, this is something further new, deviant, whatever, and then does bother to look at it. So that's one. So you have these sub paragraphs, finish your factual matrix, coming right up to the decree, okay? And in this factual matrix, you also explain the objections you have to this decree, right? Based on what exactly your pleadings, the respondent's pleadings, as well as the examination and cross-examination, documentary evidence, whatever it is, are showing, right? Then you come on to the grounds. Your grounds of appeal are nothing but an elaboration, again, one ground, one elaboration of why you are objecting to, or you feel that a particular reasoning in the order is not a good reasoning. So I give you an example. One of our matters, now the judge said that based on the preponderance of evidence, preponderance of possibilities emanating from the evidence, she believed the wife. We were for the husband. So we objected to that and we said, look, this wife has lied or omitted to tell the truth on X, Y, Z, A, B, C, D, so many instances have been proven wrong. So for example, she said that my family paid for the entire Roka ceremony, but we attached all the bills. We had all the bills and we had made the payment by our check, which we had a copy of. So that was proven to be wrong. So on and so forth. So if preponderance of possibilities has to be taken as a kind of baseline for domestic violence, then the witness needs to be a sterling witness. A sterling witness is a witness whose character and whose truthfulness are unimpeachable. And we pointed out that in this case, they were not. So she was being given the benefit of the doubt while the court knew from factual evidence on record that she had repetitively tried to lie to the court and had been caught out. So therefore, we said that this preponderance of possibilities should not work in favor of the wife, it should work in favor of the husband who till date had not even once been found to have told any kind of a lie. Right? This is just one example. There were so many others. We had a doctor's testimony where the doctor came and said that, you know, I examined her and she was given quote unquote high dose medicines. When we cross-examined the doctor, she was unable to tell us what medicines. She claimed that the girl had a cyst, but she admitted under cross-examination that she had never taken any kind of an ultrasound or a CT scan to confirm. This was just her opinion. It was not based on any medical fact or test or result or report. So, you know, again, when the trial court took the doctor's testimony on board, we asked for it in appeal for it to be rejected because this doctor had not come with any, she'd just come with an opinion. She'd not come with any kind of a scientific or a medical fact. Right? So those are your grounds of appeal. Because the learned trial court failed to appreciate XYZ, or they erred in appreciating XYZ, you know, or in holding, or in basing their judgment on this fact interpreted as so. Okay, so these are your grounds. Once you've finished your grounds, then you just come to the prayer clause, which is, of course, in the case of an appeal, it is that the decree should be set aside and the matter should be dismissed, full stop. right? So that's as far as your appellate process goes. Anybody have any questions?
Ma'am, I have a question regarding the doctor did not have any proof for the lady.
See, when you call a doctor, they're an expert witness. Now, when they come, they are supposed to come with uh, their foundation completely clear. This doctor came. She said, "I examined her as a friend. I did not take any money from her. She's a family friend's daughter. She was an interested witness." So that was proven. Then she said that she came to me because she was worried that she was being given medication and she didn't know whether it was okay, not okay. So, but she was not able to name the medication in question. So her testimony was not like that of a doctor. It was like that of a lay person. And that's what we said. She said she brought no medical expertise to the table when she came and gave her testimony. She had conducted no test. She said that the woman had developed a cyst because of these quote unquote high dose medicines. But she was unable to name one single medication that could possibly have caused this kind of a cyst, like she was saying, in the 3 month span that she was saying it had occurred. Similarly, because that question was asked to her, I asked her, can you name some medications which could possibly have been given to her? Where is your prescription? What did you write? What did you say? What did you tell her to do? There was nothing on the record. She had no records. As an expert, at least she should have known the location of the cyst by having conducted an ultrasound and said, oh, there it is. Right?
Absolutely, ma'am. Got it.
Mm-hmm.
Ma'am,
Okay.
my question is around economic abuse when he's being
Yes.
yeah
Yes.
is the DV reason of DV, and there is a court judgment passed, and
I'm
when
so sorry. You'll have to speak a little louder. You're not very
am I
clear.
am I audible now? Am I better?
Yes, you are.
Yeah. My question was when the grounds of the order are on the economic cruelty basis, and if there is an application to be filed against the order, in what ground? Because most of the time, economic things are between two people. When the husband says I gave the money, or the wife says I did never got the money, and he says I gave the money in cash, you rarely will have an evidence to prove because of this
Okay.
transaction is
Yeah.
of that nature.
So remember one thing. Okay. DV, the maintenance is awarded from the date of filing of the application, correct? Usually, that's a gap of just couple of months before the husband gets a notice. The minute he gets a notice, he goes to a lawyer. What is the first thing you advise him? Any money you're paying to your wife, do not pay in cash. You do it as an online transaction. Yes, I understand completely. But again, if you have a situation like this, and if your client has been very foolish and he has not paid in, in a traceable methodology, then you have to look for ways to prove that he gave this money. And there are ways to prove that he did indeed give this money, right? So, for example, if money is withdrawn from his account, he hands it over in cash, and the same day the school fees are paid and the amount is roughly the same, you know, and the wife has put nothing to show where she got this money from and how she produced the money to pay the school fee, which was a hefty amount, for example, then you can say that there is a reasonable assumption that I paid this in cash, like I'm saying, right? Similarly, for example, let's say, so in one of our matters, the wife claimed that the husband had not paid her anything. But the fact of the matter was that even after the filing of the case, for a period of almost 2 years, before the first maintenance order came, he was actually paying for everything. He was paying for the for all the household bills, and he had receipts of that. He was paying the school fees. He was paying the. He was even doing the shopping online for the groceries, right? So there are ways, and of course, as I said, it's important to also look at the character witness. You know, if you're able to find that the wife has been lying in other areas, you can bring it to say that, look, in a he said she said situation, she has been proven to be a liar, whereas my client has never lied. So who's the more believable of the two? And
My-
she has to prove her case. So she must prove where she got the money from to make these expenditures. In one of our matters, a wife claimed that she had been spending 1,30,000 per month till the court started awarding 1,00,000, and she was earning 30,000, right? And in the cross examination, I asked her, I said, where did you get this 33 lakhs from? You were paying out every month. Where did you get this money from? She said, oh, I borrowed it. I said, from whom and how? She said, oh, I borrowed it from family and friends in cash. I said, all right, fair enough. Can you please supply the names of the family and friends from whom you borrowed this money, along with a statement of what kind of income they have? Do they have the capacity to give you this 1 lakh? How many times did they give it to you? How much money did they give you? The minute you break it down, it becomes very difficult to prove.
Yeah, my secondary question or second question in this context, ma'am, in since this is a quasi criminal act, and in most of the criminal acts, we see that the direct evidence plays more weight than the circumstantial evidence. So, in this DV case, is it that circumstantial evidence also plays an equal importance, or in most of the cases, more importance in front of judges compared to direct?
No, actually, it is a criminal act uh, as uh, as on the statute books, but it's a quasi civil action. If you realize, when you look at DV, you will find that there is no penalizing clauses. Because when DV was being drafted, actually, what actually happened was that there was this big discussion on whether or not penalty clauses, particularly imprisonment for non-payment of maintenance, prior to passing of orders, etc., should be introduced. And the reason why it was not introduced was because of the realization that if the husband is the only breadwinner in the family and you put him in jail, how does the woman and the children survive? You see, so it's actually it's a civil act masquerading as a criminal act. What there is a prison imprisonment for is, apart from, of course, if there's a court order and you don't pay, you go to jail and you sit there till you pay. But in apart from that, the only time when you can be sent to prison is if the abuse, the physical mental abuse continues after the DV is filed, and an order is passed telling the husband to, or the in-laws, or whoever it is, the respondents, to stop, and they don't stop, and there is another incident of abuse, then the husband can, or the whoever is perpetrating that abuse, can be thrown out of the house and forbidden to come within 200 meters. Right? So that's a provision.
Yeah, thank
And
you, ma'am.
that's the penalty. Okay? And therefore, when we look at the prosecution of the DV, generally we use a civil yardstick. We prosecute it like a criminal case, but we use the civil yardstick. And time and again, if you look at what the courts have said, the courts have said what goes on in between a husband and a wife, or between, within a family, is behind closed doors. So there are very, very few actual eyewitnesses of the same. So therefore, there is a certain amount of circumstantial evidence which does come into play. Does that answer your question?
Yes, ma'am. I just wanted to know whether that would have more weightage in the judgments or in the order compared to the direct, because you mentioned that evidences of the payment being made by husband, if there are no, and if there is circumstantial evidence, the way you explained that, the amount has been paid and it has gone to fees, will that play more role?
Let me explain something to you. Okay. So when we're talking of evidence, right? One is this direct evidence. I made a payment, I put money into the bank account of my wife, and that I can show from my bank statement that there was a direct transfer. That's direct evidence, right? Now, when do you come to proving? I mean, nobody catches their ear from the long way round if they can catch it straight away like this, isn't it? You don't put your hand behind your head to catch your ear. No, you catch it from here.
Right.
So the only reason you will go into either preponderance of possibilities or secondary evidence or circumstantial evidence is why? Because you don't have primary evidence.
Right.
And in that case, the court will then consider secondary evidence.
Okay.
Yeah.
Okay. Thank you.
Ma'am, can I just ask one question? So let's say if the wife
Yeah, you can, but I think you need to move a little away from the mic, because what's happening is your voice is splitting and cracking.
Yeah, can you hear now?
I can hear you, but
Yeah. Actually, ma'am, I'm out somewhere. There's some sort of wind, so just bear with me. My question is very short and sweet. So, if the wife, on one hand, claims for the maintenance under the DV Act, and on the other hand, she files for a divorce, right? So, would the maintenance and remedies under DV Act be available to her, because she don't want to now live with the husband? She wants to be separated.
yes, they are available to her as long as she is in a subsisting marriage, number one. And number two, there have actually been some judgments of the court to say that in a 125, you can even file it after divorce.
Okay, so which means both the things are equally available, even though the wife doesn't want to stay with the husband. She has filed for the divorce.
Yes, because she's obviously claiming cruelty or whatever it is, right?
Yeah, but
Cruelty,
she is
adultery,
also asking for the maintenance, and what I understand is that you can
I'm saying
stay
that
for the
the
maintenance,
divorce
but you're
is
willing to stay with the husband.
No, the divorce is filed on the grounds of what? See, you have certain grounds available to you for filing of divorce. Usually, any one of those grounds is prejudicial to the opposite party unless it's a mutual consent, and they're saying that, okay, there's an irreconcilable breakdown of marriage. We're not talking that.
It's not the case. Yeah, it is more contested divorce.
We are talking about a contested divorce. So you are claiming that there is some cruelty, there is some whatever XYZ you're claiming. Okay, desertion, adultery, jo bhi aap claim kar rahe ho. She's entitled to maintenance. And the children in any case are entitled to maintenance, irrespective of divorce or not.
Okay. So, okay, understood. That's very helpful. Thank you.
And the courts have held that Section 125 CRPC is basically a section to prevent destitution and vagrancy. And as a result, even a woman who's unable to support herself post-divorce is entitled to come to court and ask, and the husband does have to help her out if she has no other recourse.
Okay. Thank you, ma'am. I appreciate it.
All right. Yeah. Anybody else? Okay, we are all done with appeals. Right. Now, let's say the sessions court goes against you. Then what is your remedy? Your remedy is to challenge the decision of the session court in a 482, which is the inherent powers of the High Court. Okay. The when you file a 482, essentially you repeat the format of the writ. Okay, in your pleadings. Again, you will now have to examine two layers and two levels of court proceedings and also the orders that have emanated therefrom. So from the first, the judgment, and then the appellate order sustaining that judgment or dismissing that judgment, you have to now come and take it apart and say why the appellate order is not okay. In exactly the same way as you did for the magistrate's order. The difference between these two proceedings is that now you will have to take into account what the trial court missed and what you argued that the trial court had missed and what the sessions court has not taken note of or has not appreciated correctly. Okay? Are we clear on this? Any questions? Any difficulties?
Ma'am, this will be applicable to interim applications also, no?
Yes.
Or your final.
Yes. No,
So
no, no,
even
no.
if
So for example, if there's an interim, so no, okay. Please remember one thing. All interim applications are not capable of being challenged in an appeal. Only an interim application which makes an order that affects your rights in some way can be challenged. So for example, if there's an interim maintenance order, or if there's an order releasing the passport of the respondent, and you feel that the respondent is a flight risk, yeah, those orders are appealable. Okay?
but under 482 you have to go.
Under 482, you are coming against an appellate order. You are restricted by your pleadings, you're restricted by the order itself.
Yeah, so even in interim order of maintenance, suppose the sessions court also goes against you.
Yes,
So for
yes,
that
we will
also
come to
482 will only be applicable because there is no appellate board,
Absolutely.
direct appellate
Absolutely.
board. Okay.
Yes, yes.
Okay.
You go to the appellate court. If it is dismissed by the appellate court, you go in a 482.
Okay. Thank you. Ma'am, even for cancellation of bail, suppose the same thing is applicable because sessions court gives the anticipatory bail. So in the anticipatory bail, if I have to appeal, so either it's cancellation of bail or it's 482.
Sorry?
So in the anticipatory bail, which is granted.
No. Now we are moving into different territory because anticipatory bail has a specific section. It's only places which don't have that section or don't have the applicability of that section that we apply for a bail under 227, like in UP.
Okay.
Right?
Okay, yeah.
UP High Courts don't have anticipatory bail as a provision. So therefore, you have to apply for an anticipatory bail under 227. I think from what I heard recently, that has been amended. Now you will be able to do, you will be able to go for an anticipatory bail under 482. Yeah?
Okay, 480. In UP, specifically UP. So there is no provision to go to sessions court in UP for
No,
anticipatory bail.
there's no provision to go to the High Court.
Okay.
Anticipatory bail was not applicable in UP. Now it has become. People used to go to the High Court directly in a 227, 226
Okay.
for a bail, anticipatory bail.
Good evening, ma'am. Actually, I have one question. In one of my cases, the wife has, after filing 125, and when it run for around a year or so, the wife was earlier working, but now she has left the job. She was working in a bank and in a nationalized bank, I would say, not in a private bank. And now she's claiming that she's not able to maintain herself. So can you cite some recent judgments where it has been mentioned by the court that if wife is capable of doing a job and she is well educated, she is not entitled for claiming any maintenance from the husband. Any recent Supreme Court judgment or any High Court judgment which you can cite to help the
Not off
agree?
the top of my head, but there are judgments. Yes.
Okay.
Mhm.
Okay, but that we can cite just to
Yes.
confront from the husband side, right?
Absolutely. And particularly if she was working for a nationalized bank, then she needs to explain why she left the job. No, what was the reason for resignation?
She,
And that you can ask for. You can ask for a resignation letter. File a 91. Ask for a resignation letter to be brought on record.
she is claiming that because of her child upliftment, she has left the job. But earlier, when right now the child is around 7 years old, but when the child was around 1 year old, she was doing the job. But now when the child
Yes,
is after,
yes. So attack that. Say that now the child is school going. That when the child was at home, she was still going for her work. Why she left it now? Only because, and if it was a nuclear family particularly, then all the more reason. And
okay,
is she staying with her family or is she staying on her own?
no, she is right now staying with her family, joint
So there
family.
you go. So there you go.
Okay, okay, I can attack on that front.
Yeah.
Right,
Yeah.
ma'am. Thank you so much.
You're welcome.
Good evening,
Ma'am,
ma'am.
the same thing happens on the other way. So if a husband who is earning and when a DV case is filed for maintenance, and suddenly after 2-3 months he says that he's stopped earning, he shows some kind of resignation letter from his previous company saying that he's resigned from there. Maybe he must have joined some other company now, but he's showing a resignation letter of a older company saying he's resigned after 3 months and because of the cruelty given by the wife. So now he's not earning. So in that case, how will track? See, because in RTI, if it's a government job, then to a wife can ask through RTI his salary or his income. But what about if it's a private company? How can she trace him? Because
You can
even
file
that
a 91. You can file an application under Section 91.
before
If you know where he's
registrate.
working and you want to know the quantum he's drawing, you can file
Okay.
a application under Section 91 to ask the employer to forward his employment contract. That's one way. Another way is to file a 91 and ask for his ITR, because he will not be able to disclose, to hide it in his ITR if he's getting the money in by check. Okay. And
Okay.
usually, if he's working for a company, they would prefer to pay in check because it's a tax deductible. So why on earth will they pay in cash? Makes no sense, right?
Yes, yes.
The third thing that you can do is to ask for his mobile records, because
So he's changed his
usually,
mobile number also actually.
yeah, so that doesn't matter. You can always ask for his fresh mobile number from the court to be provided.
All this we have
And
to file under 91, no?
yes, absolutely.
Okay. Thank you, ma'am.
Ask for that information.
Okay, ma'am.
First will be reluctant, but you have to say that, he's avoiding payment of maintenance by claiming that he's not working. Also, he has to then prove how he's living. Where is he getting the money to live from?
Okay.
Yeah,
Yeah.
yeah.
Good evening, ma'am.
Hello.
Madam, I have a
Hello. Ma'am, there is a maintenance case, and in that case, a husband have 12-acre agri land on his name,
Sorry?
and his wife haven't any.
No. Hold on.
Her husband.
Hold on. Can you hear me? Hold on. Okay, go back, repeat your question,
Yeah,
because
yeah.
I didn't get any of it.
Yeah.
Yeah.
Ma'am, there
Repeat.
is a maintenance case,
Yes.
and in that case, husband have 12-acre agri land on his name,
He has done
and
what
his
on his
wife
name?
haven't any
No, he has
agri
what
land.
on his name? I'm sorry, I
Huh?
didn't get that. What does he have on his name?
Agricultural land.
Okay.
He
Yeah,
own
fine. Yeah.
agricultural land. Yes. 12-acre agricultural land, and he had already sold 16-acre agricultural land, and now 12-acre agricultural land uh, uh, he owned now at the present, and
Right.
his wife
Okay,
haven't
so
any
then,
agri land.
yeah, I've
And
understood
when
your
she
question.
filed maintenance case,
Yes,
yeah.
yeah. He said, I
Then
don't
he
have any
doesn't
income.
appear in a court.
Yes.
Yeah. He doesn't appear in a court. मतलब 5 years से वो appear नहीं हो रहा है court में.
तो कोई बात नहीं है. अब
After
अच्छा,
maintenance.
anybody, किसी को अगर हिंदी में बात करनी है तो प्लीज फील फ्री, आप हिंदी में बात कर सकते हैं, कोई प्रॉब्लम नहीं है. इट्स ओके. अगर वो अपेयर नहीं हो रहा है, अगर आपके पास उसके लैंड के डिटेल्स हैं, तो आप कोर्ट से
Yes.
उस लैंड के ऊपर स्टे ले सकती हैं. वो उसको सेल नहीं कर सकता है. और अगर आप रेवेन्यू रिकॉर्ड्स एग्जामिन करेंगी तो रेवेन्यू रिकॉर्ड्स में एक नॉर्थ इंडिया में उसको गिरदावरी बोलते हैं. तो रेवेन्यू रिकॉर्ड्स दो किस्म के होते हैं. एक जिसमें ओनरशिप बताई जाती है और दूसरा जिसमें बिजाई बताई जाती है कि उसमें क्या क्रॉप हो रहा है. ठीक है. तो वो साल में 2 बार भरी जाती है. राबी और खरीफ हमारे इंडिया में 2 मेन क्रॉप्स होती हैं. तो वो
Yes.
उसमें एंटर होता है कि इस लैंड पे क्या क्रॉप हुआ है ना.
Yeah.
तो आप अगर वो गिरदावरी देखेंगे तो आपको क्लियर हो जाएगा कि अगर उस लैंड पे क्रॉप हो रहा है. क्योंकि प्रॉब्लम क्या होता है कि एग्रीकल्चरल इनकम जो होती है वो टैक्स फ्री होती है. इस वजह से कोई टैक्स नहीं भरता है उसके ऊपर. इस वजह से उसकी इनकम का पता ही नहीं चल सकता है. लेकिन अगर आप ये कह सकते हैं कि देखिए इसके खेत पे, इसके 12 एकड़ पे 200 क्विंटल गेहूं उगाया था इसने, और गेहूं का
सोयाबीन.
ये मार्केट रेट इस बार था. ठीक है ना. वीट के प्राइसेस होते हैं, राइट.
Yes, yes.
तो इसको इतना तो मिला होगा कम से कम, है ना.
गुड इवनिंग मैम.
तो आप इस्टेब्लिश कर सकते हैं. ठीक है.
Okay, ma'am.
गुड इवनिंग मैम.
और आप उसके लैंड पे स्टे ले सकते हैं कि 16 एकड़ पहले ही बेच चुका है, वो पैसा कहाँ गया इसका. तो वो ये कोर्ट को बताए और इसके पास पैसा क्यों नहीं है मुझे देने के लिए. बिकॉज किसी कानून में ये नहीं लिखा हुआ है कि जो वो मेंटेनेंस देगा वो खाली उसकी इनकम से आएगी, उसके एसेट से भी आ सकती है. अगर कोई इंसान घर में बैठ के किराए का पैसा खा रहा है और जॉब नहीं कर रहा है, इसका मतलब ये नहीं कि वो मेंटेनेंस नहीं देगा. वो उसको मेंटेनेंस देनी पड़ेगी. ठीक है. तो अगर उसके पास पैसा आया है और वो एफडी में रख के बैठा हुआ है, तो आप बोल सकते हैं कि वो उसमें से मुझे दे. ठीक है.
Good evening, ma'am.
Good
Okay,
evening.
ma'am.
I have a question, ma'am.
Yeah.
Madam, the respondent husband is not paying the final order maintenance amount to the minor daughter, as well as the compensation amount which has been awarded to the agri-5 by the learned magistrate court. But now the respondent husband has filed one appeal where he has not been granted any stay order. So in such a situation, can the agri?
Yeah, press for execution. It's very clear.
Fine.
Any order, unless it is stayed, execution can proceed.
And
problem.
And in that appeal, the appeal which has been preferred by the respondent husband, can the wife pray to the learned court to first ask the husband to pay the area maintenance amount?
Absolutely. There are a lot of judgments. आप check करिए. You can cite them to say that अगर ये maintenance नहीं दे रहा है, तो इसकी अपील की सुनवाई ना हो.
Can we get some judgment regarding that matter, ma'am, please?
I don't have it off the top of my head, but yeah, there are judgments.
Of Supreme Court, ma'am?
Yes, also.
Okay, thank you.
Where
Thank
is
you.
this case?
Pardon, ma'am? West Bengal, ma'am. West Bengal.
West Bengal. I don't remember any judgments of the Calcutta High Court, but there will be other high courts. I know definitely there are some in Delhi. There are some in Punjab and Haryana, Chandigarh High Court, and so on. There are quite a few judgments.
Thank you, ma'am. Thank you.
Anybody else? Any more questions?
Hello.
Yes.
Good evening, ma'am.
Ma'am,
Good
okay.
evening.
So, ma'am, suppose a wife has have an investment of a good amount, or suppose in lakh something. She's an educated lady, but because of the cruelty she has faced, she's not been able to work. So if she's giving a proper details of the investment she has, and it's not that she's very young something, she's in mids of her age, and she has saved that as her future amount, that because right now she's not medically fit to earn. So can court say that she has having investments not been allowed maintenance? So can you just give a light
Yeah.
on this?
Okay, so let me explain something to you. Supposing a wife is earning 30,000 rupees. Sorry, 1 second. Supposing a wife is earning 30,000 per month and the husband is earning 4 lakhs.
Okay.
Okay.
Yes, ma'am.
The wife can ask for maintenance.
No, but
And the
I'm talking about investments. She has investments.
Yeah, so I'm coming to that. What are investments? At the end of the day, investments, if she starts diving into those investments, then she has nothing left. In 4, 5, 6 years, they will run out. Correct?
Yes. Yes.
If she lives off the interest, then that interest is her income.
Yes.
So whether it's coming from employment or whether it's coming from investment, ultimately that interest is her income, right? So
Right.
what you have to do is you have to juxtapose it to the income of the husband and the lifestyle that she was enjoying during her matrimonial years, and say
Okay.
that look, she's getting 25,000 rupees a month. When she
Okay.
was staying with her husband, he was earning 6 lakhs a month, and she had a lakh to just spend on herself. Forget about the household. So that's the lifestyle. Therefore, she needs more money.
Okay. So there are judgments on this, ma'am?
Yes, of course.
Okay.
Yeah, ma'am,
Thank you
just
so much.
one point, ma'am. If so
No,
under
speak
DV
a
Act,
little louder, please. Your voice is not
yeah,
clear.
yeah,
Yeah.
ma'am. Under DV Act, what I understand is that there are three avenues available to the wife to lock the door, right? One is going to the protection officer. Second is going to the NGO, which acts as a service provider, and third is directly going to the court, magistrate
Correct.
court. Now,
Yes.
in your
And
opinion,
there's a fourth avenue. There's a fourth avenue also, which is that she can get someone else to complain on her behalf to the magistrate.
correct.
Mhm.
Now,
Yeah.
if you could help us based on your experience, under what circumstances she should choose to go to the PO or to NGO or to magistrate, or it is like as per her own whims or the advice of the advocate.
Usually it's as per the advice of the advocate. Oftentimes, wives go to the CAW cell because they want to put pressure so that the husband will start paying something or will settle up with them. So there are many reasons why a wife should go. Sometimes it's because she's filing a 498A or wo DV saath saath hi ho jata hai. So that it's a variety of reasons, and it's variable from case to case. It all depends on what you want, your client, what your client wants and how she wants to achieve it.
And ma'am, what would be the thumb rule for, let's say, people who are poor, who are underprivileged, right? I'm not talking about privilege, okay, people like middle class or lower middle class, upper middle class, poor people who are just not able to file their income tax return. They don't even have that income. So for those women, what should be the first entry point? Should that be the court, or should they go to the protection officer, NGO? Just keep those kind of women in your consideration, not lower middle class, higher class, right? Juggi jhopadi type.
So usually it's good for them. Actually, it's actually quite a tragedy because what happens to this, and I have a lot of, so I have a Basti colony near my house, and a lot of these women come to me, and obviously I tell them that look, it's a better idea for you to go to the police because the police will come, they will darao them, cow the guy, because the guy is also like, you know, not very well off economically and has no social capital either. तो वो पुलिस आती है, दो चार डंडा खड़काती है, वो डर जाता है, he starts paying up some little amount, right? So in such a situation, but they need someone to help them. So ideally speaking, my sort of modus operandi in these cases has been that if the husband has a stable job, right? So he works somewhere like a driver or, you know, in a factory, or he's a Zomato delivery boy or something like that. Then I advise him कि तुम सीधा court चले जाओ, just go to the district court and go to the legal services authority, get yourself a free lawyer and file.
Okay.
Because that's the fastest
not
way
to the
to get
NGOs and all.
maintenance. Yeah. Now, supposing a husband is a dhyadi ka mazdoor, right? He works as a laborer or whatever. Then I tell her, look, I normally send, because Jagori is very close to my house, their office. So I normally send all these kind of women to Jagori. And Jagori helps them to reach the police station and, you know, gets the police activated a little bit. So they go, they sort of threaten the husband and say you have to pay up whatever, वो कुछ देना शुरू कर ही देता है थोड़ा बहुत, but beyond that no.
Ma'am,
Got it. So which means she can choose any of these like POs, NGOs, and court. I mean, depends on
Ideally
what
it
the
works
nearby
best if you have an NGO which has a little clout.
Got it. Understood. Thank you.
You're welcome. Yeah.
Ma'am,
Somebody else had a query?
I have a question. Can I ask?
Yeah. Can you just give me one moment, please, guys?
Sure,
I'm so
sure,
sorry.
sure.
Yeah. Just give me one moment. Okay.
Sure.
Yeah. Sorry. Yeah. So somebody had wanted to ask a question. Am I audible?
Yes, ma'am, you're audible. I'm just letting that participant to unmute and ask you the question, or we
okay,
should
fair
proceed the session as of whatever you prefer.
Yeah. No.
ma'am, I have a question. It's a technical question actually.
Yes.
So, ma'am, what is happening in one of the matters is the applicant is always filing affidavit or something. Suppose there's an application, so she files in the form of a reply. But cleverly, the respondent side, no, they are not filing it in the form of a reply anytime. So it is not on oath. It is are the statements in the form of written arguments or written notes, which have misleading statements, which have false statements. So can she seek that these are misleading statements, and they have been provided to the court the same way? Can she make them liable when it's on affidavit and they have provided a misleading statement?
If I were in your position and I was representing the wife,
Yes,
I would actually draft a reply to those written statements, okay,
Okay.
and say that these written statement, parts of the written statement cannot be taken into cognizance by the court because they are not part of pleadings.
So, ma'am, you know what is happening is that every application of them making, nothing is on oath, no verification, no, just
Yes,
it's a
so
written,
the minute that is
handwritten.
there, then you have to ask the court to dismiss it, to dismiss their reply and proceed as if there's no reply. And arguments can be made only on the basis of pleadings. Please remember that. Any argument which is outside the pleadings. So what I would suggest you do is that when you can also file written submissions. And when you file your written submissions, file them after the respondent has filed and say that, look, he's filed these written submissions, but he's made this, you list it out. All of this is neither on oath nor is it a pleading, it's nowhere. And these are facts that cannot be taken into account. Therefore, this is what I have stated in my application and it has gone unrebutted.
Yeah, so every time their application is just a handwritten mirror theme, 3 paragraphs, and then signed by the advocate. There is nothing, no affirmation, no verification, no solemnly. Those
Yes,
applications
I understood, but I'm saying to you that, okay, you cannot force anybody to come and file a reply in court.
No, not about reply. Even the application, suppose they are because
Yes,
suppose the
then
first
tell the
application.
court that this application cannot be heard because it's not on oath.
But ma'am, do you have judgments on this? Because every time they file it this way and the magistrate is allowing it.
Appeal it once, the magistrate will stop. She doesn't want every order going into appeal. And file a written response to that application. Say that application bearing number so and so has been filed, and it has no verification, no it hasn't even been signed by the respondent, and therefore it cannot be taken on record and should be dismissed at the outset. File
But all the advocates say that these are the practice of lower courts, so trial courts mein aise chalta hai. This is the.
So then in that case, you point out the fact that you want it on oath because that's the law. Pleadings have to be on oath. They have to be signed and verified.
Okay. Thank you,
Ma'am,
ma'am. Thank you so
ma'am,
much.
Yeah.
Sorry. Yeah, I actually had that question, but for some reason the unmute was not working. So my question is, from the wife side, there is a DV case which has been filed, and the statements are falsified. Prima facie they are not, kind of that does not carry any kind of merit. But for some reason, it is following the general procedure of mechanically the law process has been followed. And even if the wife is been asked to kind of provide witnesses, she is delaying that for more than, it has been more than 12 to 14 months already. And the other part is the husband is also not staying in the same jurisdiction of the wife. So he's staying at a different part of India. Now, the remediation from the magistrate side, whenever it is asked for from the, to emphasize on the witness side, for some reason, the emphasis is given on the payment side that, is the husband paying, submit the proof that he's paying. So what kind of is there any other remedy that we can approach from a husband's perspective?
Is the husband paying? That's a question I also want to ask. Is he paying?
Yes, he is.
He is. Then supply the proof.
Yes, so it is supplied. It is supplied, and the court is also going back with that proof. But for some reason, the DV case is not going into the witness phase. Because from the husband side, he has been quantifying that the case,
you file an application stating that so many dates have been given and now her evidence should be closed. The judge will have to pass an order on that application. No.
Okay.
She may choose to ignore it and keep it to one side, not pass any orders, but definitely she will understand that, now you've reached a point where you are going to sort of take some further action.
Yeah. Okay. And also for the husband, is there any remedy like for, if the DV case is turned out to be falsified, by the end of the final order, can the husband kind of reclaim back the money that he has been paying?
Yes, yes, he can. There are judgments, but believe you me, it's very difficult to actually reclaim that money. Once maintenance is paid out, it's practically impossible to get it back.
Okay. Thank you, ma'am. Yeah.
Okay.
Thank you, ma'am, for addressing everyone's doubt and for bringing this conceptual clarity. Thank you for having such an enlightening session and for the in-depth understanding of major practical aspect in the SET field. It was indeed the most experience-based guidance and a wonderful session indeed. We are also at the verge of ending this session. We, the team Legal Expatiate, express our deep sense of gratitude toward our guest speaker, Advocate Roma Bhagat ma'am, for taking your time out and for enriching us with your words, knowledge, and wisdom. This session is indeed going to help us a lot in our respective field of litigation, and it was such a pleasure to have you around, ma'am. Thank you so much for your time and efforts which you have given us today. We also thank to all the attendees for being cooperative throughout the session. Thanks again, ma'am. Thank you so much.
You're very welcome. And I hope it does prove useful in some way.
Ma'am, it
Okay.
indeed was. Thank you so much, ma'am.
You're very welcome. Good night. Okay, I have to leave this meeting now, right?